And good morning, Mr. Lawler. Nice to see you.
Good morning, Senator.
So just listening to the conversation this morning, it just brought a few more questions to my mind. The first thing I might want to ask, you made a reference that that I just want to make sure I understood it clearly, which is that if something passes the legislature, it's deemed to be constitutional. I just like to have a confirmation from you that that's not necessarily the case.
If I said something that caused you to believe that, I would say no. That is obviously the legislature could pass something that would be in violation of the Constitution as interpreted by either our courts or the United States Supreme Court.
Right. Yeah, no, I appreciate you saying that too, because a lot of times today I have a feeling there is going to be references made to the current ex parte restraining order process. In fact, you've referenced it a couple of times yourself. And I would argue that law is also unconstitutional. I argued it when it passed into law back in 15 or 16. And I'm pretty certain that if it ever reached a high enough court, that's a challenge that would be successful based on the due process argument, which is like the key component in almost all the testimony that we've received in opposition. But I want to talk about this good faith belief thing, same as everyone else, because I guess my concern is this: is that we live in a very polarized and politically charged society. Would you acknowledge that there may be a sizable portion of our population, and by sizable I mean 20%, 30%, maybe more, that would agree that any person possessing a firearm might be a danger to themselves or others?
I don't know if I could answer that. I don't know. Haven't seen a poll on that in the USA Today.
Well, Mr. Lawler, I suggest sticking around for the testimony today, because I think it's going to become quite clear from the people that come testify that they believe, a lot of them do, the people that will be supporting this legislation. I would say that the majority of them are coming simply because they believe that no one should have the right to own or possess a firearm, not for any particular reason other than the fact that they just disagree with private gun ownership. So would this language in this proposal preclude someone from making a complaint against someone else simply because they believe that their neighbor owning a firearm poses a risk to them?
I don't think that would rise to the level of good faith belief of danger to themselves.
Well, I suppose that begs the question: what is a good faith belief then? I mean, people believe in all sorts of things. There's people that believe masks work for COVID, and there's people that say that they don't. There's people that believe in one religion versus another. And I don't, I have a great respect for my colleagues that I serve with on the entire political spectrum. But I happen to know that there are colleagues of mine that their good faith belief is that private gun ownership is something that should not exist. I just wanted you to acknowledge that there's a portion of the population that believes that. And we're putting something into statute that says that that's a good enough reason to take someone else's firearms.
I think there are strong feelings on both sides of this particular issue. Just as a person who observes it from the outside, I'm a law enforcement officer. That's not my focus. But as a law enforcement officer, I've observed, and there are 220 Superior Court judges in the state of Connecticut, all of which have to appear before this committee and delineate what their decision-making style is and what they use to make decisions that impact people in a variety of ways. And their job is to take the rules and their decision-making authority and make those decisions based on the laws that are passed by out of this committee and passed by the legislature. So, there are judges who have to make these difficult decisions, and I'm not paying short shrift to your comment that these are very significant decisions, and I think that judges understand that and would take guidance from previous court decisions as to what this standard means. and do their best to implement it in a way that does not unduly deny people their constitutional rights.
Well, I can appreciate that. I just don't understand why we need to change the current standard that we have, which requires the due process of law. Just, going back to a few years ago when we did the legislation on the one-sided ex parte TROs where firearms could be taken, I pointed out to several examples of cases where those restraining orders were granted. There was a Bridgeport man who applied for a restraining order, and it ultimately was granted. I don't know what other circumstances were in it, but he wanted to prevent his future in-laws from coming to the wedding. There was a Monroe man who applied for a restraining order claiming his wife and mother were poisoning his contact lens solution, and it was granted. There was another guy who said that his dog was speaking to him in tongues. I don't want to reduce the bar of when someone's constitutional right can be taken from them, as well as their personal property. And sometimes, in the case of firearms, it can be very valuable personal property, to a claim by another person, which may or may not be valid. And essentially, that's what this legislation does. Would you say, Mr. Lawler, that this essentially, I don't know, it's hard for me to understand. I'm not a lawyer, number one. So sometimes I'm at a loss in this committee on what a legal context is, but I try and use my knowledge of our Constitution and common sense to try and get to the bottom of some of these things. Are we creating a crime in this legislation? And the crime is that someone else thinks you pose an imminent danger to yourself or others. And the reason why I ask it and put it in those terms is because, as Senator Champagne said, we are already imposing a penalty before any decision has been made about whether a crime has been committed. This must be the creation of a new crime. Would you characterize it that way?
No.
So if that's the case, then how can we be imposing a restriction on someone's freedoms or taking their personal property?
I don't understand the question.
Well, it seems to me that in our system of laws and justice, ever since the dawn of Western civilization, people are accused of crimes, but they're not punished until after the crime has been adjudicated. In this case, we are effectively punishing someone. And so to me, that means that we are establishing a new crime. You don't see it that way?
No, I believe that the statute would be civil in nature and would require, it isn't talking about putting anybody in jail for being a danger to themselves or others. That's a crime.
Well, respectfully, I'm sorry, I didn't mean to cut you off.
Civilly, until another determination is made, and that being based on a foundation of due process within a framework that has already been established on the civil side that meets these goals if the legislature deems it.
So is it your testimony that the taking of personal property or the restriction of one's right to defend themselves is less important than taking their personal freedom, like their ability to move freely by being put in prison?
I'm not going to equate one thing to another thing. The statutory framework that we've suggested, which we believe meets the intent of what this current bill is proposing, would be a framework that would be legal in the state of Connecticut and would effectuate, I think, the intent of what's proposed here.
I appreciate that. And again, I'm not trying to conflict with you, personally here in any way, shape, or form. But I believe you did just say that you said, well, it's not like we're putting someone in prison. And
it's not a crime. It's not a crime.
Right. Well, again, so if that's the case and it's not a crime, I guess, and I don't want to go back and forth on this, and I'm sure a lot of people have to ask a lot of questions, but if it's not a crime, then in my opinion, there should be no penalty either. And this is the purpose of due process in our state and federal constitution. So that's my
asset forfeiture too. We take people, the asset forfeiture, which has been modified to a great degree over the last several years. The
right, I'm responsible for that, Kevin. That was my proposal.
Senator, for a second, I'm just gonna, because it's happened a couple of times, and I'm trying to give some leeway, but can we try not to overtalk each other in the exchange so that it's clear for everyone who's listening?
My fault, of course. I'm sorry. I'm excited and delighted to have this opportunity to be engaged in this conversation. So I guess my final question is, what do you say to the many people who are contacting me and writing testimony to this committee that I think are making a pretty clear and straightforward argument that this bill does not provide for due process as constitutionally prescribed?
I would say to them that I believe it does, based on some of the other the temporary restraining order, civil protective order legislation that has passed before. And again, I understand that this is a political issue and that there are folks who believe it's an overstep. I believe that's a political issue that should be discussed amongst yourselves and with your colleagues, and that there should be a vote on it. And if people believe that it is unconstitutional, that they would have their avenues to have that heard in a different form.
Yeah. Thank you for that answer. But again, I would make the same argument about the existing law. So can we just get to the bottom of how this satisfies due process, which, the 14th and the 5th Amendment both say no person shall be deprived of life, liberty, or property without due process of law. And in this case, we're certainly depriving someone of liberty and of property. And due process is described as, you're innocent until proven guilty. And clearly, in this case, you said there's no crime because there's no proven guilty. And so I don't get it. We're punishing someone for a crime that is not a crime, and due process hasn't been met. So that's all I would like you to do. I mean, you're a major proponent of this legislation, so I would like to understand how we satisfy the due process requirement of the state, other than to say just the current other unconstitutional law is proof, because it's not.
Senator Sampson, let me be clear. The Division of Criminal Justice has proposed this language in support of any particular position. This was presented as a potential issue that affects the Division of Criminal Justice, that the state's attorneys, Chief State's Attorney Colangelo, myself, and others intimately involved in these types of decisions attempted to present a workable format that, if it were the will of the legislature to effectuate something like this, that we would recommend that it be done in this particular fashion. That, we're not here advocating for anything other than we are discussing and providing advice to all of you who have to make these decisions, given our expertise in the area.
Forgive me that I didn't have a chance to read your testimony. I went online this morning to look at the testimony that's been uploaded. I didn't find it there. It may be, I just didn't see it. But my impression from your conversation with Representative Dubitsky is that you were here supporting this legislation. So forgive me if I'm mistaken. I've got no further questions, Mr. Chairman. Thank you.
Thank you. Representative Rabimbis.